Hello to my Law of Contracts class. Welcome to week 2 of summer session 2020. I want to start by first apologizing to all of you who had any difficulties getting the online book. We weren't given a choice between hardbound and the online. We were told by the administration that because all summer classes would be online, the bookstore would not be open, would not be having people come and go and expose maybe to others to getting sick. And so the bookstore with the publisher of the books put together the books that you would buy online for this summer session. And quite frankly, the whole thing seemed to be a fiasco last week, not just for my classes, but for several classes that, not to blame anybody, but between the publishers having 5 or 7 steps for you to get access to the book you buy, and the bookstore not being familiar with the books themselves or not having an all online bookstore, we ran into all kinds of problems for students. And I'm sorry if you had to go through any of that. I'm assuming that everyone has now gotten their book, and that, believe me, the rest of the semester will be smooth sailing because I'll be in charge of it. Okay, so what I want to do in this next 15 or 20 minutes is I just want to talk about what your assignment was last week, what it's going to be this week, sort of give you an overview. So last week you got the book, you saw I sent my syllabus, you saw the taped lecture on YouTube, and you were assigned to read chapter 11. Chapter 11 is the very first chapter this semester. It is the nature and terminology of contracts. And one of the things that I explained is that you are going to have 4 assignments, 4 small writing homework assignments this semester. Each one will be worth a maximum of 25 points. Depending on how well you do with the assignment, you could get anywhere from 0 to the full 25. There will be 4 of them. So the 4 together, I will add up the points you received on your assignment, and that will equal 1 test grade at the end of the semester, along with the other test grades that you will have for the normal exams that I send. Okay, so your very first assignment, worth 25 points for last week, that you are to send in this week to me by Tuesday, is at the end of the chapter, there is a Mitsui Bank case. You are to read the case and answer all 4 questions. The 4 questions are really great questions because they're general questions or a little bit more specific. They get us started on contracts and definitions of contracts and the kinds of things courts are looking for when a case comes before the court. Okay. This week, and I'll send them out, your assignments out on Tuesday and Thursday, but this week you're going to receive my notes on chapter 11. I like to call them my lecture notes. Pretty much cover the things that I would cover if we were face-to-face in class. So you will have your book, you will have the assignment, you will have my notes to help you through each chapter. And that's pretty much the format we're going to use. This week in chapter 12, you are also going to receive an assignment. Chapter 12 is on agreement, one of the 4 elements required for the court to enforce a valid contract. And an agreement, a meeting of the minds, the intent to enter into an agreement is what Chapter 12 is all about. And it requires an offer and acceptance of the offer. So as you go through Chapter 12, you will see, and there's lots of examples That's the really great thing about this particular book, is that even in the little sections, there are also examples of principles and concepts that they talk about. However, on 232 in my book, I don't know how the online book is numbered, but it's in chapter 12, is a landmark case. This case, Lucy versus Zimmer, is from 1954, and it's out of Virginia. This is a great case, and this is a great case to read about. It's also a great case to discuss in class. Lucy versus Zimmer, again, we're talking about agreement in this chapter. So every example that they give will somehow be tied to that requirement in a valid contract of agreement, of a meeting of the minds of the parties and of the offer and acceptance. And so Lucy versus Zimmer is an amusing case because it is a case of two couples. One wants to buy the other's farm, and they've had a few drinks, and they make an agreement, or it looks like they make an agreement, or one of them thinks they've made an agreement and that they're going to buy the farm. And what happens is the next day, the other party who owns the farm at the time says, that was just a joke. We were drinking. I didn't really agree. Well, they bring the case to court to argue over whether they actually agreed. And one of the things you'll see in chapter 12, it's not just yes, it's was their intent, and what facts does the court have to say these parties intended at the time to enter into a contract. And you will see that the court here found that even though there was some drinking going on, they believed there was a valid offer and acceptance. And in fact, the wives of these two gentlemen play an important part because the husbands got them involved in this decision and this agreement, which further showed that it was, to the courts at least, that this was a serious negotiation and it ended in an agreement with all the terms the court could enforce. Now, what you'll see in this chapter 12 is that some of the things that the courts look at. So just saying yes, there was a legitimate offer and acceptance is not enough. There have to be certain factors that a court, how does a court interpret, how does a court enforce a contract that they find actually existed, but that the contract has to have enough detail that the court's going to know who the parties are, what they've agreed to, what the subject matter is. Have they agreed on a price or performance or a place? Or that at least the essential details are in that contract. If they don't have those essential details, then chances are they're probably not going to find that there was a contract or that there was a completed contract because they don't have enough information before them to enforce contracts. And remember what I always say, when we look at and study cases in law classes, these are the cases that something went wrong. The vast majority of cases, everything goes right and no one brings the case to court. The ones that come to court are in court because the parties themselves are having a disagreement. One of them didn't do what they were supposed to. One of them may be claiming that there's not even an agreement or a contract or an offer or acceptance. The other thing that you're going to learn is not only the offer, but when can it be accepted? And also when someone makes the offer, that's the offeror, the person they make the offer to is the offeree. When that happens, can the offeror take back their offer? And so this chapter talks about situations in which the parties or the offeror may withdraw that offer. Also, they talk about termination of an offer, which is what we're talking about, and how there are two categories of termination of an offer. The first being by the action of the parties themselves, the second being by operation of law, and they will distinguish that, and there's even a chart entitled Methods by Which an Offer Can Be Terminated. And then the second part of the chapter is going to be about acceptance. What is acceptance, and have the parties specified the only way to accept this offer is, by a certain date or in a certain way, or is it by email, is it by snail mail, whatever the parties have agreed to. More likely than not, the court is going to see if that's been complied with and only enforce it if the terms have been complied with. So you have to be careful to read any contract that you enter into and know what it says, because you're going to be held to those terms of your contract. Also in here, we're going to see the mirror image rule, and we're going to see the mailbox rule. Now, these are two concepts that have been around since common law, and just briefly let me touch on them. So the mirror image rule basically says that I'm making an offer and you can only accept by accepting my exact offer, not changing any terms of the offer itself. That's unequivocal acceptance, and that's the mirror image rule. I make the offer, take it or leave it. The mailbox rule basically states that if you're going to accept the method or mode of acceptance. Now, it's called the mailbox rule because if you can accept by mail, by old-fashioned mail, then acceptance is complete the moment the offeree deposits their acceptance in the mailbox. Not when the offeror receives it, but when they actually drop it into the mailbox. Now, if the agreement calls for an instantaneous type of thing, like email or text, then you have to read the terms of the agreement, because it might be when the sender sends the acceptance, or it might be only accepted once the offeror receives it. So you've got to, again, in contracts, it's incredibly important to read all of the details to make sure that, in fact, you have complied with what you agreed to do in the manner you agreed to do it. And then the third part of Chapter 12 is about e-contracts. And let me just address that for a moment. So, what's an e-contract? Well, in times gone by, and people still use this, when a contract was formed, two people, more likely than not, will sit face to face and they will negotiate the terms of their contract. Today, we do very little face to face. We send emails, we send texts, and negotiations are done through electronic resources rather than face to face or even snail mail. And so the question becomes, are e-contracts, are contracts that all of the contract, all of the negotiations, and all of the communications have been done through some kind of electronic communication? Well, you're going to see when you read the last third of this chapter that the basic and general rule is, yes, e-contracts are valid and enforceable in the same way as if you and I sit across the table from one another and write up a contract or talk about the elements of a contract. It still requires all of the things: agreement, consideration, contractual capacity, and legality of subject matter that a written or face-to-face negotiation of a contract would require. However, there are some differences in online offers and acceptance, and on 242 you want to read what an online offer should include, like the acceptance of the terms, the payment, the return policy, any disclaimers or limitations on your remedies, all of those things. And also pay attention to how are we going to settle any disputes that might arise over the contract itself. It will also talk about online acceptances and things like shrink wrap agreements. Shrink wrap agreements are a little different than traditional sort of agreements. A shrink wrap agreement, the terms of the agreement are expressed inside the box that the package or the goods are packaged in. And the party who opens the box is told when they read the shrink wrap agreement inside that they agree to the terms by keeping whatever is in the box. So when you order software or a computer, they go on about shrink wrap agreements, enforceable terms, when they may not be enforced, also browse wrap terms, click-ons. Let's talk about one of the last things in the chapter, and that's electronic signatures. So it's very important to know that an electronic signature is just as legal and enforceable in contracts law by the courts as your own pen to paper type of signature. And in fact, there is a federal law that says the E-Sign Act provides that no contract, record, or signature may be denied legal effect only because it is in electric form. In other words, under this law, an electronic signature is just as valid as a signature on paper, and an e-document can be as enforceable as a paper one. Now, the only thing you have to look out for there is that there are certain exclusions. There are some exempt documents that require a person to actually take pen to paper. And it says an example of documents that are exempt from an e-signature include often certain court papers, divorce decrees, evictions, foreclosures, health care or health insurance, prenup agreements, and wills. And so, at least for the time being, although the federal law recognizes electronic contracts and signatures, you must be sure when you are involved with an electronic contract that your contract is not one of those areas that excludes the electronic signature, which doesn't mean you can't negotiate the contract through electronic means, but it means that in the end, there must be an actual signature on legal paperwork for it to be enforceable. Okay, so I think that is an overview of agreement and chapter 12. I want you to be reading chapter 12. I'll send my notes for 11. Please read that. And I'm going to send an assignment on the case of Lucy versus Zimmer. Every time I send you an assignment, you will also be told when it's due. And it'll always be due on either a Tuesday or a Thursday. And generally speaking, because this class would start at 6:30, I say that it must come to me no later than 6:30 on the day that it's due. So just pay attention to the emails that I send out because it'll have more specific directions on it. So again, I am so sorry for those of you who had so many difficulties trying to get your book. I hope everyone has their book, is online now with their book, has access to it. If for some reason you are just getting it, please just send me an email that you're going to be, a day or so late with whatever assignment is due. And then hopefully this week is going to start us not having to worry about, your books. You have them, and I'll be sending the assignments. And I'm hopefully going to do a short video at the beginning of each week during this summer session, just to feel like I have some connection with you and you have some connection with me. But please do not hesitate at any time to send me an email about questions or problems you're having, and I will get back to you as soon as I see it. All right, take care, have a great second week, and I look forward to this course this summer session. And also, it's supposed to be a beautiful week. I hope you're healthy and your family's healthy, and you get an opportunity to enjoy the great spring weather that we're having. All right, thank you and good night.